Good morning, everyone, and welcome to the IFS PD webinar on estate planning. For those that don't know, IFS has had a very long relationship with Estate First Lawyers, probably well over 10 years, I believe. They're one of Australia's largest and leading estate planning teams in Australia. And today we've got Anne Jansen, who's the Divisional Head and Special Counsel of Estate First, a business she founded way back in 2009 and is very active in the business and in advice community. She had a booth at the FAAA Congress last year, and I know a few people went up and said hello to Anne and her team. As well, she's very active in different spaces, including the National Director of the Women in Super Board, as many other industry bodies and committees. And joining her is Josh Fillo, who's a Senior Associate at Estate First Lawyers, and was back in the business since 2011, so he's been there a long time as well. He's practiced exclusively in estate planning law and estate administration law since joining Estate First Lawyers. Now, we are recording this session and it will be made available on IFS Ash for those that can't make this session or wanted to review it or have a look at the slides. Now, it's been a long time since we've had an estate planning update, so thanks very much for Anne and Josh for presenting today. If you do have any questions, just put them in the Q&A box and we'll monitor them along the way and try and get to those questions either during the session or at the end, depending on how we go for time. And that's pretty much it from me. I'm going to put myself on mute and hand over to Anne. So Anne, thanks very much for coming along.
You are welcome, Craig, and thank you everybody for joining in. It's great to see you again. And of course, we started the IFS partnership back in 2014. We were a lot younger then, weren't we, Craig? But it's been a wonderful journey with you guys in helping your members and your clients with their estate planning. And the FAAA was a wonderful thing. And for those who didn't go, I did speak at the FAAA on the diminishing capacity of clients over the years as they head into their older years and how financial advisors should navigate that. And that will be a session that I sort of roll out over the year. So if you're interested in that a bit later in the year, I think that would be a very good session to run. But today, the session is connecting the dots. And so IFS has asked us to basically give a session that is about, when should you be talking to your clients about a comprehensive estate planning service as opposed to just a will and an enduring power of attorney? What does it even look like? Why do you need it? That's when you would be referring to us if you want to. And so we're going to talk about that. And we're also going to talk about what it looks like for your clients to come and see us. What are our turnaround times? How do we approach this? And we're always very transparent with costs with our clients. So we're actually going to run you through what it's likely to cost them in terms of getting that comprehensive advice and all the estate planning documents that they need. So it's going to be a good session for you to be able to, well, it'll equip you to talk to your clients in a meaningful way, and hopefully they get their estate planning done properly. All right, so I'm going to give you a few stories. So just a general disclaimer that, don't use this advice. Remember that as advisors, you can't give legal advice, but you certainly can give legal information, and you certainly can guide your clients onto the right path. So obviously some of these case studies are going to be quite relevant, but remember, every different client is nuanced and individualistic. Just very quickly, on the next slide, I'm just giving you a quick overview. We'll just quickly mention about us for those of you who aren't aware of us or don't know us well. Then I'm going to talk to you about the conversation triggers, and there are three conversation triggers that, if you're aware of them and you can have a 10 or 15 minute, if you can, conversation with your clients, it is going to be a wonderful thing for you to do. remembering that as a financial advisor, you're probably the only person who can lift the awareness level of the client in relation to the estate planning needs. And then we're going to talk about how we work, feedback, pricing, and so on. Alrighty, so let's get started. That's our team. We're just about to add another person in Sydney who starts on Monday. So that brings the team up to about 10, I think, lawyers. Estate planning is our specialty. We're, I think, the only firm that actually focuses solely on estate planning. And we're one of the largest teams in Australia, and we offer an Australia-wide service. So that's good for our Victorian and New South Wales advisors as well, where our head office is in Queensland, but we certainly do it Australia-wide. We love to educate our clients, and we try and bring the conversation to a level where they can actually understand some of the sophisticated issues or topics that we raise so that they can actually adopt them. We try and do 3-week turnaround times on even complex estate planning. And of course, we love to work closely with the advisors. So, and every advisor is different as to what you want after the meeting, before the meeting, and so on. I'm going to talk a little bit about how to fill out your X plan, and I've had a look at your user guide and your data forms. Craig's been very good and is going to add a few extra questions to those data forms to make the information we get when you first refer more meaningful. And so we'll go through that as well. So it's a bit of a practical session as well. All right. So, and on our next screen, one of the first things that we have to understand, and our clients have to understand, is that a will is not an estate plan. All right. So just like advising on super is not a full financial plan on all of the client's assets. Okay, it's one important part, but it's not everything. And the will actually only covers assets that the client has in their own name, or if they hold property as tenants in common, then it will fall under the will. But there's a whole heap of other pots of money that are not automatically governed by the will, or not governed by the will at all. The big one is superannuation, and we all know that binding nominations and RPNs are the way to drive super. Now, you can drive super to the will, you know, in that regard, but maybe you want to, and then sometimes maybe you don't. That is a legal conversation, so don't get roped into that one. You can tell your client the importance of getting it done, but refrain from telling them what to do, who to nominate. Joint assets go to joint survivor. They do not go under the will. But if both people die, it will then. Insurance, well, if insurance is in super, of course, it's going to go in accordance with super nomination. But if it's outside of super, then it has its own nomination. And it's really important with clients to talk about the death benefits tax that is on the concessional component of the super. And it gets, of course, even higher when you're talking about the insurance in super. And clients are not aware of that, but that needs to be a conversation piece, because that will change the way they want to leave their assets to different people, such as a second spouse and adult children, most of the time. And of course, if your clients have any kind of entities, like family trusts is the big one, or SMSFs, then those entities have their own estate planning requirements, and the will does not reach into those assets, those trust assets. So you can see there's a whole heap of stuff outside of a will, but most clients that come to you, even the ones who are pretty sophisticated, will tend to think that all they need to do is a will. And just on the next slide, you can see just how many items we have to do, and I call the circles on the first page magic circles, but they're really pots of money. We haven't even touched on incapacity when we're looking at that. And as estate plan, must definitely have a decent conversation and robust documents in relation to how the client's assets are managed if the client doesn't die, so the will has no effect, but is incapacitated. So there's a lot to talk about with clients, but if they get it done right, I can tell you now that things will go smoothly if they die or if they become incapacitated. It's kind of like if the more you plan, the better things go. If you don't plan, the problem that you have is when you're incapacitated, you can't sign anything legally, and you certainly can't if you die. So then we're in a whole world of pain of how do we rectify things, and often we can't. All right, so let's look at the why of why it's important. Well, you guys know why it's important, but let's just go there one more time. Do you know that the baby boomers are starting to get into their more golden years? And they've accumulated a lot of wealth, largely thanks to super, but also because the property market has just boomed. And so they're leaving a lot of intergenerational wealth. And you're going to see more and more of that over the next 2 decades. And of course, it's way, way more than what we were seeing parents leave children, say, 30 years ago. This is a whole different ballgame. Now, when you have a lot of money, you have 2 issues in inheritance law. The first is there are taxes, and yes, we don't have death duties, but there's a lot of tax opportunities we have, and there is that death benefits tax on super, so don't forget that one too. But also, have you heard the expression, where there's a will, there's a relative? So when there's a big pot of money, out from the woodwork come all of the eligible estate claimants. And so one of the fastest growing areas in the law at the moment is, and has been for the last 10 years, is estate claims. And so we do need to educate our clients on that. Most people will have some risk of estate claim. It's just some have minimal risk and some have high risk. And I'm going to just walk you through that as well. All right, so it's time to have a quiz. And we don't have the ability to poll, but so what I'll do is I'll just walk you through, and I want you to have a think and of this. So this question. Now, KPMG did this survey about 12 years ago, and they came up with an answer as to how many inheritances actually will not get down to your grandchildren level. So I call that the L-shaped inheritance. So instead of going down line, like let's say I leave everything to my husband, Peter, then I leave, when he dies, he leaves everything. If I die first, he leaves everything to Sam and Ben in equal shares, our 2 sons. And then if they die, it goes to their children, which are my grandchildren. I don't have any yet, but I hope to one day. That's there. If this is being recorded, I can play it back to my kids.
Well, good luck with that one, Anne. But yeah, people can put it in the chat if they want. If they want to have a guess.
Oh, can they?
Yeah.
Oh, nice. Yeah. Okay. So Josh, I'll let you look at that. So what I would like you to do, it'd be great, is how many inheritances, how much of my inheritance will not reach my grandchildren on average. Okay, so if I say have $1 million to leave and it goes, let's say to Peter, then it goes to Sam and Ben, and then it goes to their children, how much is going to get to those grandchildren from me when it's all washed up in the end? So let me see, are we getting any people coming in?
We've had one brave person have a guess, but come on, everyone, get in there and have a guess. There's no penalties for getting it wrong.
Oh, no. How are we going?
We've had a couple of people having a go, but yeah, everyone wants to put a figure in out. A few people are having a guess now, so that's good.
Yep. So Craig, you can tell me, because I've got the answer on the next page, but I'm not going there until I get a few answers.
Yeah, well, we've got very mixed. I think it's all over the board. There's no consensus. Some people are saying 10, 30, 50, 70. So the chat's
Okay.
disabled, so you've got to put the answer in the Q&A. Thank you for the clarifying that, Desiree. The chat's not working. So the Q&A is fine to put your response in.
Oh, yes, I see. Very
Yeah. So
good.
there's quite a few people
Oh,
guessing, and
that's
we're getting
good.
yeah, we're getting a lot of different
Yep.
results.
Yep. I'm very interested to see this. Now, we call this the L-shaped inheritance. So in other words, how much of my $1 million is going to go L-shaped? i.e., it's not going to go downline, it's going to go off to others. Maybe I die first and Peter gets remarried. Kind of think he would, you know. But anyway, and what happens if he doesn't get remarried, but he gives it all to Sam and Ben and they have a breakdown? And so maybe some inheritance might be lost that way. You see?
Mhm.
All right. So let's have a look. Does Craig or Josh want to tell me what people are doing in the Q&A?
Well, thanks for the 27 different people that answered, but it's pretty even across the board.
Okay. So do you want to know the answer?
Yes, please. Yeah.
All right. There it is. So congratulations to those people. Now, of course, we don't have hard statistics on this, but when you're talking KPMG, you know, we're talking about someone who counts numbers, bean counters, some would call them. So if $700,000 of my 1 million is not going to get to my grandchildren, that's a real issue. And there are so many very good ways that we can stop that bleed. And so that's what I also want to talk to you about. Because remember, in estate planning, prevention is better than cure. And you can prevent a lot of this stuff happening just by getting proper estate planning done. All right. So let's keep moving it along. Now, to me, the most critical role in a client's estate planning is actually their financial advisor, if they're lucky enough to have one, because it's the financial advisors that are seeing the bigger picture, they're seeing the long-term picture, and they're actually stopping and having a conversation with their clients about this point, because it is the end game and you can work hard all your life, but then it's the last chapter still matters. And all's well that ends well, and all of that. So, but you know, I often find that, you know, most accountants are not having this conversation. Maybe it's just not coming up when they go to do the tax returns. They're not going to walk in and just see us, you know, out of the blue. So really, you are a pivot point in this whole process. And as I was saying before, you know, your great value in the equation is to shine a light and show people why it's important and what to do about it. And I mean, if you've done that, that's you've gone a long way to the clients getting this stuff done properly. All right. Next slide, Josh. They won't let me operate the slides. I think I'll do a bad job of it. Of course, that's not true, I think. Okay, so let's have a look at the conversation starters. And there are 3 main conversation starters which also speak to the 3 main things that really summarize and pinpoint the things that could be wrong with what the clients have got now. The first one is who drafted your will and how good is it? Not all wills are created equal. Okay. And, you know, if they've done a DIY will, that's going to be a real red flag for you. The second one, and actually this one is a really easy win for you, is to ask the clients if they have testamentary discretionary trusts in their wills. Now, if the clients have more than $1.5 million of net assets approximately in their wealth, they should have had a conversation with the lawyer they saw on testamentary discretionary trusts or TDTs in the will. And if they say we didn't, because they'd remember if they did, because it's quite a big discussion, but if they didn't, you can sort of think they probably saw a lawyer that's more of a generalist and didn't really give them all of the tax and asset protection advice that estate planning should do, particularly when you've got a decent swag of money. Okay, so that's an easy one. And the third one, and very important one, is are they at a higher risk of an estate claim? And the classic example of a higher risk individual or couple are a blended family. So out of all the estate litigation that happens, by far the majority of it is happening with blended families. Children of first marriage versus second spouse. Yes? Okay. So there's a lot of blended families these days, and a lot of them will not understand that that is a risk for them, and that's where the litigation sits. So we're going to just quickly talk about those three items. Okay. So now we'll just quickly put all the dot points there. Now, this is, I'm sure Craig will give you the PowerPoint afterwards. But look, if you're stuck sort of for words and they've got, a will that looks a bit sort of questionable, or certainly if they've got a post office will or a DIY online will, I think the first thing to say to them is that's probably the most expensive will you'll ever do. And I'm going to show you why in the next case study, which is a real case that happened, but don't go there quite yet. Josh, just go back a little. No, yeah, thanks. And the reason is that wills have very technical legal language. And the reason that they have such technical legal language is because you cannot interview the person who did the will after they die. So you can't go and say, look, what did you mean when you said you're going to give this to X, right? Whereas with a contract to purchase a block of land or something like that, you can query the parties after and say, well, what did you mean? Right? And they can clarify what they meant. But in a will, you can't. And so the law says you have to look at the strict language of the will. So you can imagine a DIY person doing a will, not even knowing what the strict language is and the trouble they're going to get into. And if that does happen, it has to go to the court after the person dies on construction. And that is a very expensive exercise. So we're going to have a look at the case study now. And this is a true story. I love true stories. And this is a guy called Bill. He lived at Wandai and he died when he was 89. But before he died, he did a simple will. And in it, he said, I give the sum of 100,000 to each of Annette, Jane, and Paul. They were his nieces and nephews. He did not have a wife or children. He was a very, very important part of the Wandai community. He was very active in his church as well, and all round a good egg kind of guy. Now, when you look at that language, right, the question that the executor immediately had was, well, is that 100,000 to Annette, 100,000 to Jane, and 100,000 to Paul, i.e. 300,000? Or is that 100,000 to be carved up a third, i.e. $33,333? That was the question the executor wanted to ask. Now, why would the executor take that to court to get the court to tell him what to do? Well, it was because Bill had around $1 million of assets, and the residuary beneficiary was actually the Catholic Church. And so was the Catholic Church going to get 900,000, the balance, or was the Catholic Church only going to get 700,000? So they're interested, and certainly Annette, Jane, and Paul are interested because 33,000 is a lot less than 100,000. Can you see the problem? Now we're going to go to a quiz. Remember, you can do this in the Q&A. Right, okay. I want you to choose between these three options. Have a read of, these are the exact words that were in the will. And you tell me what the court decided the words meant. Did it mean 100,000 to each of them? Or did it mean 100,000 to be shared between them? Or was the clause actually void for uncertainty?
That's while people are doing that, Anne. I heard a situation where someone was literally on their deathbed and just wrote on a piece of paper what they wanted to happen. Have you come across that, and how does that normally express itself, and does that get considered as a will?
It can. So we call that an informal will. Now, a formal will has to have a signature on it and two witnesses, yes, and be in writing. It doesn't have to be typed up, it doesn't have to be long, but it does have to have those elements to it. And if it has those elements to it, it's gone a long way to being a formal will. If it doesn't, and it's just written on a piece of paper, particularly if it isn't signed, the whole issue of was this the will makers or the person who wrote it, was it their intention to actually be a binding will that took effect? Or was it just like me writing, a note where I'm thinking about things and it's on my sort of note paper or my journal of what I'm kind of thinking of doing? You see, and so informal wills can go to court and then there can be a whole case put together of, no, this was their intention, or nah, it was just a bit of a jotting down of thoughts and ideas. And that is a very expensive exercise, but it can end up being a last will that is binding.
Right. Okay. All right. Again, we've had some mixed responses. Probably mostly people have put three, but we have a good spread over all the answers. Someone said that it depended on whether the judge was a member of the Catholic Church or not. But
That's good. I like that. That's
yes.
funny. Okay, so that's really interesting because I have posed this quiz to advisors before, and almost always the advisors as a majority pick number 3, which shows that, they've got some legal sort of, knowledge there, Craig. They're sort of exercising their legal knowledge. But when, if this was a contract, right, then the courts are much more partial to saying, yeah, it's void for uncertainty. But when it becomes a will, another principle that comes into play is that the judges are loath to void a clause because they're trying very, very hard to make the will operable. And so they want to pick one or two. So let's have a look at what they picked. Now, I picked the wrong one when I first read the case because you don't get to hear the ending until you read the end of the case. So this is how ambiguous it is. But that is the answer. Now, I say, having done this for 30 years, I reckon that Bill meant to do number one. That's my gut just says, because he was leaving the balance to the church. So, yeah, and these were his closest rallies. I reckon he meant to give them 100 each. And it did say to each of, yes? So, but that's not what the court decided. It was 33 grand. All right. Now, what happened to the Catholic Church? Let's have a quick look. Oh, the legal costs in this case were over 100,000. And this case is itching on 10 years old now. It'll be 150 now. So that's a lot of money to pay for a will. And of course, it was poorly drafted. Yes. Now, the Catholic Church residuary beneficiary. This is what was said. I give the residue to the Catholic Church of Queensland, Brisbane. And the problem was that there is no legal entity called that. but there are 5 legal entities in Queensland, and that's their proper name. So this case went on for like 50 or 60 pages, and the judges are trying to work out which Catholic church Bill meant to leave it to. And it went into his whole history of which churches he'd been to, and over the years, I mean, it just went on and on and on. And in the end, they went, oh, I don't know, just leave it all to all 5 equally. And, and there were the costs that were involved. Now, you might think this was actually a DIY will, but it was actually drawn up by the local solicitor. There you go. And so that's how easy it is to get it wrong. And that's basically all I want to say about that, is that it is not a generalist area anymore. It's become, I don't know, like everything, you kind of have to specialize these days. But anyway, life's more complex now. All right, let's go to the next thing. Did you like that story? Poor Bill. I felt sorry for him, but I guess he was gone, so it didn't matter. I don't know.
No, it's a good story, Anne. Probably didn't worry Bill now, but yeah, no, it was a good story.
Worried Jane and Annette and Paul, I guess, but they
Yes.
only got 33 grand. But anyway, so I would not be asking, or it asking, do you have an up-to-date will, is not as good as asking what the quality of the will is. And they kind of course won't know. So you've got to kind of dig around a bit. I mean, if they've done it themselves, it's not going to be good. Trust me, guys. Even lawyers who practice in other areas, they come and go, we're a lawyer, we do our own will. I go, nah, no, you can't really. So what is the quality of your will? Do you have testamentary discretionary trusts in your will, or did you at least have that discussion? Did you have a discussion about estate claims? If they're saying no, that's kind of telling you something. All right. So I think we can, that's just some answers for you if you are faced with this, but you can just tell them the story of Bill, and that'll put the wind up on. All right, next slide. What have we got? I think, Josh, I'm handing over to you now, aren't I?
You are. You are. Thanks, Anne. So, as Anne mentioned, testamentary trusts are a conversation really you should be having with your clients, and most of your clients will want this once you explain it to them, once they know what it actually is. As we've talked about, there's no magic in how new the will is. It's all about the quality of the will, and part of that is knowing, was the client given information about testamentary trusts when they did their estate planning? Or to put it another way, when they did their will, was a conversation had with the client around protections for the inheritance if a child goes bankrupt, if a child dies and leaves their assets to their spouse, or if their child has a relationship breakdown. A testamentary trust is one of the ways we can avoid that L-shaped inheritance. Anne mentioned briefly what the L-shaped inheritance is, but it's basically this. So clients want, ultimately on the left-hand side here, for one of them to die in a standard single family, the first spouse to die, leaving it all to the surviving spouse, and then down to the child, and then down to the grandchildren. Ultimately is what they want to see happen. When we talk about an inheritance going L-shaped, we mean instead of it going down, it jots off to the right-hand side there. And that child might inherit the money, but then that child dies, divorces, goes bankrupt, and it ends up doing this. As opposed to this, it goes L-shaped and over to that child's then ex-spouse or child's spouse if they die, or the trustee in bankruptcy. So there are some significant risks to your children's inheritance in a simple will. And testamentary trusts are an easy way to provide for that protection. To use a very simple example of a single family of how their will might be structured. We've got Roger and Barbara with 3 children of their union, Michael, James, and Bianca. So standard mum and dad with 3 children. This might be the type of testamentary trust structure that they might like. Leaving everything to each other at first level. So if one of them dies, they're still leaving all their assets to the surviving spouse. But instead of leaving their assets to each of the 3 kids direct, they give each of the 3 children a testamentary trust. And each of those 3 children, as you can see down the bottom there, can still be the sole trustee of their own trust, their own third share inheritance, which means they can still do whatever they like with it, but it's a lot better protected in the event of one of those claims occurring. Looking inside that blue circle, how it works is a lot like a family trust. If you've had anything to do with family trusts, they are similar in their operation to family trusts, but with a narrower class of beneficiaries, primarily limited to bloodline, which helps to preserve that asset protection, particularly as against children's spouses / ex-spouses. So you can see here for Michael's trust, he will be the trustee, or he can be the trustee of his trust. And the potential beneficiaries include himself, his kids, his grandkids, other lineal descendants, or other companies or trusts that he might set up for tax benefits, for some tax advantages. Primarily, the main advantages are these. Tax advantage. Testamentary trusts are really highly concessionally taxed because it allows children to stream income to their own children at adult marginal tax rates. There's no penalty tax regime that applies in respect of testamentary trusts, unlike family trusts. So they are very highly concessionally taxed. Increasingly, I find, though, that the better, well, not the better, but the more important attraction for clients in doing these is the second dot point, which is protecting against the L-shaped inheritance. I find that that is generally what drives most clients to do testamentary trust wills, given the significant amount of wealth that they are usually passing on to their children. So again, a bit of a script, and as Anne mentioned, we're very happy for Craig to share these slides around so that you've got this information after today. The question might be, do you have testamentary discretionary trusts for your beneficiaries in your will? And the client might say, no, my lawyer, maybe a generalist lawyer that they've seen for 50 years, said I don't need that kind of stuff. You can't give legal advice, but you can give information. So you can recommend that you get your will reviewed by an estate planning lawyer to determine whether you should be including them. They have tax and asset protection advantages you should be aware of, and which otherwise your beneficiaries won't have, and I can provide you with some information. Having that conversation can be a very different experience for your client because, as we've mentioned already, unless you alert them to the fact that these estate planning options exist, they won't otherwise know about them. When do clients need them, though, from a cost-benefit perspective? Our rule of thumb generally is $500,000 per child or testamentary trust. So if a client is leaving at least $500,000 per beneficiary, they definitely need to have a conversation around testamentary trusts, and most likely they will end up proceeding with them. To put it in a more precise example, the Roger and Barbara scenario, they've got a property, they've got some investments, super, they've got a total estate of $2.2 million. If they've got 3 kids, there's over $700,000 per child, so they're definitely warranting a testamentary trust. Or for a single person, again, unit, it's investments, cash, super, bit of life insurance, total estate of 1.5 million. If they're dividing it equally between two children, again, it's definitely worthwhile a testamentary trust. A Bianca, someone who maybe doesn't own a house, they've got a little bit of cash, a little bit of super, but they've got some life insurance. Perhaps they wouldn't want one if there's only 400,000 per child. So if they've got a total estate of 800,000 divided between two kids, they may not want a testamentary trust, or it might not be worth it to them to do it. That, however, I have certainly done testamentary trusts for the Biancas of this world, because some clients are interested in it, notwithstanding there might be less than our rule of thumb. So it's again a starting point to have that conversation with clients. Importantly as well, whenever you start mentioning these sorts of things, trusts and lawyers, to clients, sometimes they worry about that there's going to be massive big bills that come with that. We are very upfront with our costing, and you guys have access to our price list through the system, but that is the price for testamentary trust wills. So you're on the discounted price list. So it's $2,600 for a couple for both, or a single person $1,700. So we're not talking tens of thousands of dollars for them to do this. It's definitely worthwhile having that conversation. That also includes our meeting time, a letter of wishes. If, however, they are more complex, such as a blended family, or if they've got any complexity such as structures, there's likely to be some extra costs involved in that. We have a lot of information on our fact sheet on our website about testamentary trusts, and I would encourage you to have a look through, share that information with clients as need be. It's all freely available. It gives a lot of good information about how these things work. These sorts of clients, so the other conversation starter is if clients are in a higher risk strategy, higher risk sort of category, they will generally have an idea that they are more complex, such as they are a blended family, de facto relationship, they've got estranged children or children with disability, or the other complexity is potentially they've got a number of structures as well. They definitely need to have conversations around the potential for estate claims. Each state has very different rules as well, but generally speaking, who can bring a claim against an estate? It's spouses, married or de facto, children of any age, stepchildren, and in some cases financial dependents or interdependents. Clients that are in that category definitely need to have that conversation because they are very expensive. The legal fees often come out of the estate. Even if a claimant potentially doesn't win, the courts can still take the legal fees out of the estate because there's a bucket of money there. Probably more importantly than the money, though, is the breakdown of the relationship, because you're inevitably ending up with children or stepchildren, step-siblings, or siblings or step-siblings suing one another for more money. And inevitably the wrong people get the money because the lawyers end up with most of it. Or maybe that's not so wrong. Who knows? There are lots of strategies that we can look at to minimize that risk. We can put assets into joint names, so have joint ownership of property. We can look at superannuation and life insurance nominations. So going back to those blue circles, super and life insurance doesn't automatically fall into the estate. That provides us with an estate planning opportunity to nominate beneficiaries direct and keep assets outside of the estate. Family trusts are another good option. investment bonds increasingly as well. And we can also look at transferring assets during lifetimes to intended beneficiaries. New South Wales, just a bit of a disclaimer, New South Wales has notional estate provisions which can impact the viability of some of these strategies. But it's definitely still a conversation that needs to be had with any client that are in those high risk categories. So, to bridge that gap, conversation would be, are you in a blended family de facto relationship, have an estranged child or child with disability? That's the red flag. And the advice piece, a conversation you can have might be, well, you need to get your current documents looked at to see if your plan is at risk of a claim. Estate claims are on the rise, as Anne mentioned, very expensive. They can result in your estate being depleted and the wrong people getting the money. I think Anne is taking over here and then I'm coming back in.
Okay. We can put down the information there. So guys, when you're filling out the X plan, you will have these extra questions in there. I realise that bullet point 2 with the client assets is not one of the question prompts that you will have, but there's a nice box down the bottom where you could put in just a bit of extra stuff, which often you do, and I really appreciate it. But marital status, obviously, it's going to be a different plan depending on whether you are single or married. And if you come to the meeting without your partner because you don't want your partner there, again, they're all different conversations, so helpful to know that beforehand. The other thing that's really helpful is to know, are you in that blended family, situation where you've got kids, he's got kids, or one of you got kids, the other doesn't, or even you both got kids and kids together. That's a real tricky one. What state that you're in, you always fill that out really well because every state has different estate laws, just to keep things interesting. And if they have companies, trusts, or SMSFs, then we need to know because that's a higher skill level. Blended families and entities are a higher lawyer skill level than where they don't. And we match the client's complexity level with the lawyer, the seniority of the lawyer in the team. Okay, so what will the clients face when they come and see us? So that's the next slide. Basically, we have 2 client liaison officers who love talking to people and really shepherd the people along, tell them what information that they need, make the appointment with the right person, the right lawyer, and give them lots of information about the first meeting. So that's really helpful. So clients come in feeling prepped. There is a $350 fee for the first hour and a half. And after that, it's at hourly rates if clients want to stay longer. Often, the kind of clients we get that need comprehensive advice do. There's a 3-week turnaround time between the first meeting and when clients are signing up, unless it's particularly complex or we can't get the instructions from them quickly. But we're all pretty good at having those conversations and giving the clients the options. And look, honestly, 94% of clients proceed from that initial meeting. So I think that meeting is being done correctly. If we quickly go to the next slide. So here I just want to show when do you refer to us and when don't you refer to us? Well, look, if the clients don't have a lot of money, like Josh was going through those scenarios, if a client doesn't see the value of advice, if the client, doesn't have enough money to really warrant discussions around how you protect that stash, how you get that stash to the next generation, what are the tax implications and things like that, then they probably shouldn't come and see us because they'll think we're too expensive. The clients that see good value, because the value that we give in terms of having testamentary trusts and wills our advice around super, blended family structuring, and entities, we're really doing that very, very well. And I can tell you now we're at least 30% less than the big city firms. And so they will see the value for money. Just on that point, and I might just keep going very quickly because running out of time, we might have questions. And of course, you're more than welcome to answer questions. I might just quickly show a typical example of what a client could be up for, just so when you're talking to the client, you can sort of say to them, look, to get, if you end up, and you don't have to end up with TDT wills, we do standard wills too. Of course we do. They're not actually all that much cheaper once you count all the meeting time and so on, but they're going to be maybe 60% of that testamentary trust fee. But you get your enduring powers of attorney, you might get advanced health directives or MTDMs, as you call them, Victoria. There's a bit of advice on the super. They might have extra meeting time as well. They're really not going to get any change out of $4,000, and then add GST on top. So that just gives you a bit of an idea. But that's a one-off fee. Yes, they do have to review their estate planning. We recommend every 5 years or sooner if something changes significantly. But our estate plans are very robust and cater for a lot of change. But that's just a rule of thumb because I know that was one of the questions Craig wanted me to address. For a single person, which is that one, the next one, yeah. You're looking at $2.5 to $3 grand for a proper estate plan. But if you do have that kind of money, it really benefits you to properly do the estate planning, just simply because the costs of not doing it right are so huge. I just quickly throw a testimony up of a super fund member who wrote to us. And I just think this encapsulates a lot of the feedback we get. But he said, with Estate First Lawyers, I have now made use of testamentary trust, which gives me a high level of comfort. Also, I've now made advanced health directive, letter of wishes, binding death nomination. I wasn't aware of any such documents. Such a shame. Until I met EFL. This guy's a retiree. So he's had other wills. And I'm glad I decided to go with EFL because now he has got the full comprehensive stuff that he needs. And I think that testimony really encapsulates what we do for your clients. I just want to jump to the locations and how we do things. Remember, 94% of our clients proceed after getting the quote at the first meeting. So I feel that we've got the pricing right, and we've got the value proposition right. Brisbane, we can do face-to-face or virtual. Sydney, we can now do face-to-face or virtual. Melbourne is virtual, but we do have a lawyer that we get to sign people up in New South Wales and Victoria, so that they are not hunting around for a JP. All other locations are virtual. We give them really good signing instructions so they can go and get their 2 witnesses for their wills and their JP for their power of attorney. But that's how we're doing the actual physical meetings or virtual meetings across Australia. And I'll probably end on the feedback. Every year we collect all the client feedback. We send out a survey after everybody has finished their work and got their bill. And that's the client feedback that we've collected over the years. And that's a real testament to the team that they really, really put the clients first. And I think we're done. If there are any questions, we're happy to answer them.
Great. Thanks, Anne and Josh. That was great. Very entertaining and informative. And it's always good to come along. I know it's been a while, so it's good that you came along and presented today to give, put a face to a name and give confidence when people send referrals off. And so that I think it's important that we do that from time to time. So thank you. And it was really clear again on Yeah, as you mentioned, I wanted to know what your process was, so the advisors know how things work and how things operate. And as you mentioned, we're going to be updating our form a little bit, so you've got that bit of extra information going into the meeting, and the financial advisors can definitely relate to that because that's exactly what they do. Well, that's what they want before they meet with a client as well. So that all makes a lot of sense. And thanks to Diane and Jeremy and our team that are updating those. Yeah, and oh look, that's great. Thanks, Dan. He's just posted in there that he's had some really positive feedback as well when he sent some referrals off. Um, I know, and we mentioned at the start that you are one of the larger firms that do provide estate planning across Australia. It's amazing. Yeah, when I first looked into this a number of years ago, there's not actually many businesses that do provide Australia-wide coverage. And I mean, someone in the comments, Kate, she's from Perth, wanting to know if there's any plans down the track to put someone in Perth. When we looked across, yeah, there was very, very few firms that have Australia-wide coverage. So I'm not sure, and it's just probably too hard to get an actual in-person at every state and city.
You know, it absolutely is. And every state is different. And so that's why I'm actually struggling to think of an Australia-wide estate planning firm. I
Yeah.
think there are
Hmm.
ones, but I am actually I think maybe some of the big firms would have a branch in every state, but I can't think of any firm that specializes in it, certainly that does it
Mm.
Australia-wide.
No,
And it's
Australian
just
Unity
because,
used
yeah,
to do something, but they decided that that wasn't for them and a few years ago. Yeah.
a lot of the trustee companies have gone back to their knitting, so to speak, and
Mm-hmm.
gone, it's really hard running a law firm and a trustee company. Let's not do that anymore. And so perpetual equity trustees and so on have kind of ditched us lawyers out of their sort of service offering. And again, because it's just got too complex out there, Craig.
Mm-hmm.
Just like it is with financial advice, it's not easy.
Yeah.
Do I plan to go to Perth? I love Perth, I
Yeah,
must
Perth's a great
say.
spot. Yeah.
Um, but I think COVID did us only one favor, and that was to get everyone used to doing virtual meetings. And we have spent a lot of time and money
Mhm.
getting our virtual conversations right with clients, with diagrams and structures and stuff, so that they have as good an experience as possible.
Yeah,
Yeah.
I'll probably need to pick your brain on some of that as well, actually, because I know obviously a lot of our advice teams have done the same. So that would be interesting to see how you go about that.
Mm.
And what I might do, Anne and Josh, is reach out to you separately, but we meet up with the financial planning leaders of all the funds that are on this call. And so if anyone did need any additional training, we can speak to the specific funds, and we'll come back to you if if maybe they want to reach out and have their own internal training.
The FAAA one, where how to navigate incapacity in clients as it diminishes for financial advisors.
Hmm.
I think that one is a good one, maybe to run past them.
Great.
If you want to.
Yes, thank you. Well, thanks everyone for joining and taking part in this presentation. It was great. As I said, very entertaining and informative. We've recorded the session, so it's going to be available early next week on our intranet site, Ash. And for those that have attended live, your CPD will also be updated early next week in the Kaplan on-track training plans. But again, thanks everyone for joining me, and we'll see you all again soon.
Thank you very much. Have
All
a
right.
good
Thanks,
day.
Anne. Thanks, Josh. I'll talk to you again soon.
Thank you.
Okay, thank you, Craig.
Bye.
Bye.
Bye.